Welcome, everyone. You already know the routine. I'm Broward, Executive Director of the Broward County Bar. Yeah, your mics, you're muted. If you're not, please mute. And it's my honor to introduce our president, Jamie Finizio-Bascom.
Good evening, everyone. I hope we have everybody that was intending to be here tonight. I know this is not one of our usual exciting yay topics where we're going to be like having cocktails and doing something fun, but it's something important that we need to address. So I thank all of you for being here to listen to this, because it's something where we all want to make sure is considered well as it's being proposed. And we have our Board of Governors that are spending their time, and a lot of time has been spent on this to be able to suss through it. So thank you to all of you. I would like to start off with introducing our panelists that we have here that are assisting to sort through this and to be here as specifically as the Florida Bar had asked them to do, to be here as informants of the issues and to be able to educate our membership on the issues as they are being faced. So starting off, we have, of course, Lorna Burton, who is one of our Board of Governors for many, many years. She's been on, and she's also campaigning for president-elect of the Florida Bar. She's been involved as long as I can remember, since I was a young lawyer back in 1993 on the Board of Governors, and has been doing an amazing job for our circuit. And of course, the other Board of Governor members are here as well, who have done an amazing job as well. My dear friend, Diana Santa Maria, who as well has served for many, many years and given many hours to the Florida Bar and to our local bar as well. And each of you, this goes without saying, have been incredible supporters of our Broward County Bar and everything that we do within our county. The same goes to my dear friend Hillary Creary, same thing, young lawyer days way back when. We were both baby lawyers and had babies back then, back in 1993. Hillary Creary's done an amazing job for our circuit in so many ways as well. And of course, none other than the amazing Jay Kim, who in fact has been there as a stalwart for our circuit, always being at the Florida Bar level, and all of the other organizations as well, serving for Broward County and representing us well. And also it's his birthday tomorrow, so we were just teasing him about that we want to make sure we end at 6:30 so he can start celebrating his big birthday. He's turning 40 tomorrow. So yes. So thank you to all of you for being here. And we're going to start off with Ms. Burton. If you can start your presentation, and we will take questions and comments at the end. And we'll go through the PowerPoint first, just so we can stay on track, because there's a lot of information.
Yes, so good evening, everyone, and thank you for being here. We do have still some members to come, but we wanted to remain as much on time as possible. As Jamie has shared with you, this forum, this town hall, is to get your feedback on what the special committee for the Florida Bar has presented us. Actually, the Supreme Court committee has presented to the Supreme Court task force. So to get us started, Jamie, I don't know if it's going to be you or Braulio is going to be assisting me with that PowerPoint. Awesome. So we'll just utilize this PowerPoint, and certainly we will wait till the end to ask for your feedback, and we'll just go through that. So Braulio, if you can go on to the next slide. But as many of you know, or should know, the Supreme Court sent a letter to our then president, John Stewart, directing him to establish a special committee on the delivery of legal services to study a variety of topics. They included lawyer advertising, referral fees, fee splitting, entity regulation, regulation of online service providers, regulation of non-lawyer providers of limited legal services, and additional topics consistent with the subject study. Next slide. In that regard, the composition of the special committee, and I won't go through that, were a variety of number of people, except for one member who was a legal technology consultant. everyone were attorneys with the Florida Bar, and they covered a variety of circuits as well as practice areas. So that's the composition of the committee there with those persons. Now, they then broke themselves up into a variety of subcommittees based on the issues involved. And so the subcommittees, they were divided as following. The one committee was to review Rule 4-5.4, professional independence of a lawyer, and accompanying ethics opinions. So there were about 7 committees. The second committee was to review of pertinent advertising rules as found in Chapter 4-7 of the rules regulating the Florida Bar. A third committee was to review Rule 4-7.17 relating to payment of referral fees to persons other than lawyers, including related rules and ethics opinion. The next committee was to review of the lawyer referral services, including Rule 4-7.22 for-profit, and Chapter 8, not-for-profit, and related rules and ethics opinions. The next committee was review of regulatory framework, including entity regulation, regulatory sandbox, and related concepts. Another subcommittee looked at member and public engagement and data collection and review. And the last committee, review of advanced Florida registered paralegal proposal. From there, they then, next slide, Braulio. They then submitted what is known as the final report that contains several recommendations. And if you guys have not done that, I do encourage you to go and take a look at the that special report. I know in our flyers out about this, there was a link to get to that. However, we can also make sure that that link is forwarded to all of those that attended here again today, so you can take a look at that report. Anyway, the committee took final action on certain items and voted to approve other items in concept only. And we're going to review these items by the subcommittee. Now, the first one is dealing with the review of, let me do this here. Sorry about that. The review of Rule 4-5.4, professional independence of a lawyer and accompanying ethics opinion. Now, with that, I am going to, okay. With that, the committee suggested that Florida follow Utah law and unanimously voted to approve in concept the following recommendations of the subcommittee by studying Rule 5.4. Their first recommendation was to amend Rule 4-5.4 to permit non-lawyers to have a non-controlling equity interest in law firms with restrictions. Now, this was, again, approved in concept, similar to the Washington, D.C. rule that allows for non-lawyers to have a non-controlling equity interest in a law firm with restrictions. Specifically, the work of the non-lawyer must actively support the work of the law firm. The special committee explicitly voted that professional rules should not be amended to permit passive ownership of law firms. So again, to be clear, not to permit passive ownership of law firms, but to permit non-lawyers to have a non-controlling equity interest in the law firm with specific restrictions. Okay, so the next slide goes on to explain review of Rule 4.4, professional independence of a lawyer and accompanying ethics opinion. If passive ownership is explored, and again, they're not recommending that, but if it is explored, they're saying it should be done in the context of the proposed law practice innovation laboratory program so that its safeguards can be put in place and data collected. So the recommendation here is within the law practice innovation laboratory program, eliminate the restriction on fee sharing with non-lawyers under Rule 4-5.4. Next slide. Okay, continuing again with the review of Rule 5.4. The recommendation here was to amend the rules to allow for not-for-profit law firms. And this was again approved in concept, amending the rules to permit not-for-profit legal service providers to organize as a corporation and to permit non-lawyers to serve on the not-for-profit legal service providers board of directors. This conforms the rules to current practice. So as noted again, the recommendations anticipate that if the recommendation to establish a law practice innovation laboratory program is adopted by the court, all or part of the recommended changes would be placed in the lab for implementation and study. Now, this is similar. Okay. I see Alan's question, and I think, Jamie, you'll note that question, right?
Yes, I will.
Okay, thank you. Alan, we will definitely do that, and I'll allow any of my colleagues to respond to your question. Yeah,
Good question. Pretty
yes.
general.
Yes, a little general. Okay. The next slide, Braulio. So what we wanted to do is just go through all of these, and then we'll come back and specifically, as I said, ask for feedback, address questions at the end. The next recommendation had to do with review of pertinent advertising rules as found in Chapter 4-7 of the rules regulating the Florida bar. The recommendation there by the committee unanimously voted to approve amendments to the advertising rules in concept. And what happened here was the committee found that these conceptual amendments would streamline the advertising rules, making the language of the rules more succinct and eliminate any processes or requirements that are no longer as appropriate or necessary as they may have been in the past. Okay, the next, Braulio, thank you. Review of lawyer referral services, including Rule 4-7.22 for-profit and Chapter 8 not-for-profit and related rules and ethics opinions. The committee agreed with the subcommittee report that Chapter 8 lawyer referral rule should not be amended. So how that stands, they voted not to amend that rule and leave it as it is. Next. Review of regulatory framework, including entity regulation, regulatory sandbox, and related concepts. The committee voted that the court should establish a regulatory sandbox where the recommendations approved in concept may be tested and appropriate data collected. The regulatory sandbox is referred to in the report as the Law Practice Innovation Laboratory Program, or the lab. Although the committee voted that the lab be established, the format was approved in concept only. All right, the next was the review of Advanced Florida Register Paralegal Proposal. And the recommendation there by the committee is that Florida explore this option by approving a pilot program allowing Florida registered paralegals to provide limited legal services in specific areas and within a law office. So in essence, as said here, the committee is recommending that a pilot program be tested in the lab. The limited assistance paralegal pilot program would allow a qualified Florida registered paralegal to assist a client in preparing and filing legal forms, provide some information to the client regarding their legal matter, and provide ministerial assistance in court proceedings. In brief, the activities the committee approved improved in concept are the selection, completion, and filing of forms, providing some information, and assistance with court proceedings. Again, the committee did not recommend a rule change and instead recommended a pilot program be included in the Law Practice Innovation Laboratory Program so that the concept may be tested. So, additional action that was taken by the committee. The committee also voted to recommend to the Florida Bar that it promote a better understanding of Rule 4-1.2C of the rules regulating of the Florida Bar. Now, this rule allows lawyers to limit the scope of their representation and provide unbundled legal services. As noted in the comment to the rule, a limited representation may be appropriate because the client has limited objectives for the representation, or because the client may wish to exclude actions that the client thinks are too costly or which the client regards as financially impractical. The committee found that although this option is available to both the lawyer and the client, it is underused. Providing education in this area will help lawyers understand the rule. With better understanding, the rule may be utilized more with clients reaping the benefits. So that was an additional action that the committee took that was not necessarily inside of the other 4 or 5 areas that were asked to be looked at by the Supreme Court. And then the Law Practice Innovation Lab Program, or the lab as it's also known as, is where most of the recommendation the committee made are changes in concept only, with changes taking place in the controlled environment of the Law Practice Innovation Lab Program, or the lab. A lab or a regulatory sandbox is a mechanism where the court or a body appointed by the court permits entities that may be different from a traditional law firm to offer new and innovative methods, ideas, and types of legal services without a wholesale amendment of the rules. The committee's recommendations included that a lab participant be licensed and allowed to continue offering its services after the lab formally concludes, unless there is evidence of harm to the consumer. All right, and so that brings us to the conclusion of what the committee did. Now, we are asking for your additional comments, feedback, questions, concerns, and I'll get to Alan's. And you guys can also, if we don't get through everything today, email scinput@floridabar.org. That's capital S, capital C, Supreme Court input @Florida, FLORIDA, BAR.org, and provide more feedback in writing to us, the Board of Governors, as well as the Florida Supreme Court. And so I want my colleagues to jump in. I don't know if anyone wants to specifically answer Alan's question, and then we'll begin to take other feedback, concerns, comments, questions.
Yes, and
Go
Lorna, if I can, just for one moment, I also want to welcome Adam Rabinowitz as well. He joined us. He is also one of our Board of Governors, and I think that we have a full count now of all of our Board of Governors. So thank you, Adam, for all you do for our circuit and for our membership and for being here as well.
My pleasure.
Yes, thank you. Okay, go ahead, Lorna. So did you want to?
You can go ahead and read Alan's question, and any of my colleagues can jump in and respond.
Well, who would like to answer the $1 million question of, can you explain what all of this really means and why it is being done? In other words, Cabana Girl head is hurting, and there's so many moving parts of this. So I think it's a great question to understand the origination of this, how it came about, and who would like to handle that. Perhaps one of you that have been on the Board of Governors, maybe the longest, that was there for some of the initial discussion points when this came up a few years back as well in a similar type of format. Who would that be?
Okay, none of
Guy-
my colleagues. Okay, so I'll go ahead and
I
attempt to
was just gonna
tackle
say, I
that.
choose Jay.
Oh,
You
good.
choose Jay?
Hillary, did you
How
want to go
about
ahead?
Jay?
No, I was
Yeah,
gonna say,
Lorna's been on the board as long as I have. It's she and I probably have been the longest standing ones.
well, there you
Yes,
go.
yeah.
Let's not throw
it's
Jay to the
Adam
wolves
and-
just yet.
It's
All right,
Adam,
Adam,
it's
yeah.
myself, then Adam and Diana, then Jay and you, Hillary. Adam, do you want to take it, or do you want me to?
Oh, no, go right ahead, please.
Oh, thank you so much. Okay, so the brief history is that, as I said, in 2019, the Florida Supreme Court wrote a letter to our then president, Jon Stewart, and directed him to establish a special committee on the delivery of legal services. And they were directed to study a variety of topics. That included, again, lawyer advertising, referral fees, fee splitting, entity regulation, regulation of online service providers, regulation of non-lawyer providers of limited legal services, and any additional topics during the course of their committee work that would be consistent with that subject of the study, which is, again, the delivery of legal services. And so that's how this committee was formulated. Those were the issues that the Supreme Court asked them to take a look at, and then to come back by, which they did, they met their deadline by June, which was a few months back, and give this special report or submit to them a report on what their findings are, what their recommendations are, what were their conclusions. And so that report, which again, I encourage all of you to look at it, basically the first 21 pages, there are a lot of attachments to that of the things that they looked at and studied. And you guys are certainly welcome to look at that, but the report itself is about 21 pages. And this is the report that they came back with and made their recommendations to the Supreme Court. Now, we asked the Supreme Court for an opportunity to get feedback from the members such as yourself, and for you guys to have an opportunity to share and express whatever concerns you may have, whatever questions you may have, and so forth. And that is where we are. So.
Thank you, Lorna.
Okay. Go ahead.
Well, that doesn't really answer my question, okay?
Okay.
The question is, who's looking to benefit for this? This smells to me like corporate America trying to get their way into our law firms and take them over. This smells like legal Zoom practicing law in Florida through the back door. Is that what's happening here?
Okay, so Alan, I can't answer that because I don't know that to be the case. What I can share with you is this came directly from the Supreme Court. Now, I do know that over the years, the Supreme Court has had, concerns regarding the delivery of legal services. They have certainly heard some of the same stuff that we have heard, that there is still 80% of the community that needs legal services, can't afford legal services, that although we have legal aid, they are not necessarily able to provide all the legal services to those that can't. And so this was something, again, that came from the Florida Supreme Court. What went into their thought process that was not expressed in the letter, as far as I know. And my colleagues are certainly, again, if you have any further comments in that regard, please chime in.
Well, I would like to know what the position of my representatives on the Board of Governors is on this issue.
Okay, go ahead. Actually, at this time, Alan, we want to know what your position is. We don't necessarily, at this point, we have not debated it. We got it the same time everybody else did. And that's why we're having these, to find out, because we represent your interest, what you guys believe. So the feedback that you guys are going to give us will certainly facilitate that process and definitely assist us in making sure that your opinions are expressed and debated and reviewed prior to anything coming out of the Board of Governors.
Lorna, I love you to pieces, but I'd like to hear from the other reps
Absolutely, I want them
on
to
the Board of
chime in.
Governors as to their opinion on this issue.
And yes, and I was just going to interrupt and say that we have a lot of questions here that I'll read through, but absolutely, I think they haven't made their decisions, but I think it's important for them to hear you all and how you feel, because they're going to be representing their constituents, and that's the whole point here. So Alan, well taken on that. We also have Paul Regenstorf here, who also wrote, you can see in the chat, just as Alan was stating, he's interested in knowing what the problem is that someone needs addressing, and that he's bothered for. So we can read through those questions, but I will go through now each of our Board of Governors and let you each speak to this issue, starting with you, Adam, next, if that's okay and you're ready as well. And again, this is to educate the membership so that we can then send personal emails, Alan, just as you all are writing, that needs to go to the Florida Bar. I personally am in agreement with what you all are saying here as a practitioner and not understanding why this is a priority for the Florida Bar. And that's what we're here to voice with these representatives who are here. Go ahead, Adam.
Sure. Number one, I'll say when I was on the Board of Governors, when Ray Aberdeen had his commentary at the General Assembly when he got sworn in and mentioned reciprocity, I'll tell you, it was a surprise to all of us to some degree, shocking, troubling, not just as a member of the Board of Governors, that's responsible to represent constituents, but we didn't see it coming down the pike. There were clearly things that were happening at that point, but we didn't know at that juncture that Ray was going to be taking that position. I could tell you I was clearly against it. I can't tell you how many emails I got that just echoed the same sentiment that I had. At that point in time, I was a partner at Broward Cassell, and I wasn't as worried about it. Now I have a smaller firm. Me personally, I don't want, as you mentioned, Alan, for example, corporate America invading my practice. I believe in the sovereignty of what it is that we have. I've been doing this for 21 years. But to echo what Lorna said a moment ago, understand this is not Zoom telling the Florida Supreme Court to the Board of Governors, go ahead and investigate this stuff. This is the Florida Supreme Court telling us, hey, look into this circumstance because we need to find more efficient ways to deliver legal services for not just us, but for our community, people. The Florida Supreme Court, believe it or not, they dictate to us those things we should look into and evaluate. It doesn't mean ultimately that any one of us, I could tell you from being on the board, I think this is my 7th year or 8th year, Lorna, you can correct me if whatever year it is. But listen, when I read this report and I look into the things that they want to look into, I'm not pleased. I'm not happy about it, to say the least. That's my personal opinion. But like any representative of a constituency, my obligation is to follow what you all suggest we should do with this circumstance. We represent, obviously, one of the largest counties in this entire state. And I'm not necessarily looking forward to my inbox getting flooded with everybody's emails, but I can promise you this, I don't like it, me personally. But ultimately, my obligation is to follow whatever it is the constituency of this county suggests should be the direction the practice of law should go in. So, you know, my temperature and tolerance for what I think you called the invasion by corporate America. Ultimately, I'm responsible to follow the constituency, which I think is consistent with my personal beliefs as well.
Thank you, Adam.
Does that
Okay.
answer the question, Alan?
Yes,
Thumbs up?
absolutely. Thank you,
Okay.
Adam.
My pleasure.
Okay, Diana, can we have you now weigh in, please? And then we'll continue to address these questions in our discussion points with each representative.
Sure. Good evening, everybody. Nice to see you all here. And I would like to add that there are other representatives, other Board of Governor representatives from the Florida Bar Board of Governors, Saya Baker Barnes, Scott Westheimer is on. But, you know, all of us as Board of Governor representatives, we are here in two capacities. One, as members of the Florida Bar, and secondly, as leaders. So there's a distinction here between how we feel personally, and we can't speak for the Florida Bar, but since you asked, I have grave concerns about what is being recommended by the special committee. And by the way, nobody on this, on the Board of Governors, I believe, is on that special committee. If I'm wrong, Lorna, please correct me.
Correct.
But this is not a done deal. This is simply a recommendation by a special committee, a small committee. And now it is a process by which they are seeking our thought process, our opinions. And I would encourage everyone here, don't just rely on your representatives and leaders, but right through the process, because we are all members of the Florida Bar and we all have a voice and should convey our sentiments and our concerns. When this came up years ago, it was soundly defeated and it was slightly different issues, but generally the same. So I would strongly recommend everybody to voice your opinion. Don't sit back on your laurels on this one, because we do not want at least, you know, me personally don't want the legal profession to change the way it potentially can in the state of Florida. So those are my thoughts. I want to make sure I save room for the others that are here to speak.
Thank you, Diana. Okay, so Jay or Hillary, and again, I apologize, I did not introduce the others. They're not from our circuit specifically, but we do have, I understand, yes, no, but thank you for being in attendance. I think it's very good for you to gauge for your circuit as well, Scott and Saia as well. And so we welcome both of you from your respective circuits. Okay, so Jay, would you like to weigh in now on issues?
Certainly. I don't have a whole lot more substantive information to add. I think everybody's spoken to the points that I would have said if I had gone first. I just like to add this, you know, and I can tell you that there is a dichotomy between my personal feelings, which is probably the same as the rest of yours. I'm kind of like, why are we trying to fix something that I never thought was really broken before? But as lawyers, I think we are in an industry that is resistant to change. I ask you to think back 2 years ago, just 2 years ago, when if you were to go to any court in the state and say that you wanted to attend a hearing by a video call, that you would have been soundly rejected out of hand. And we've changed that paradigm 180 degrees. And so I'm not saying that there is any rightness to this. I don't know right now, but I think that there is always a quest that we have to improve the delivery of legal services, which is one of the things that we have to do. And so let's not have a knee-jerk reaction. Let's look at things and study them. Because personally, I'm against all of this, but I think I also have a duty to study it and give it due consideration. So that's all I want to add. And I'll just tell you that personally, I have feelings, but I cannot, just looking at the members of the special committee, these are not people who are out to destroy the bar. I serve with these people, several of them, in my years on the Board of Governors. I know them personally, and I can't imagine that they're trying to benefit the corporations. But you know, we have to look at everything and look at it as analytically as possible, and try not to just have an emotional reaction. So I'll just leave you with that.
Thank you, Jay. I appreciate that. All right, Hillary. Ms. Burton?
Yes, just briefly. So I share everybody else's statement that what is important here is not my personal sentiment about this. I have read some of the background paperwork, and I've read the final report. And again, I may not be a fan of all of the parts of it, but I understand the purpose. I've read the letter that was sent to John Stewart. And basically, we're being asked to balance a couple of things. One is the future of the practice of law. It's going to look differently than it did, as Jay said, 2 years ago. So I think the Supreme Court is trying to be sort of visionary about how we deliver services, given the change in how we practice law. And the question is, so things are going to change. It's already changing in the rest of the world. Florida has always been a leader in innovative ideas and practices. And so how do we do that? Deal with the reality that the practice of law is going to go through some changes, and still protect the community, protect the public. So we still have lawyer regulation, but are we going to make it easier for law firms to advertise? Are we going to offer services that would not traditionally otherwise be offered? And as Jay said, we are adverse to change in the legal profession. But I think that if we don't consider the possibility that some of this might actually work, that we're going to get left behind, because things are going to change whether we're on board or not. So do I personally agree with everything? Well, if you break it down into its small parts and you look at some of the changes, for example, I am studying a particular area of this, and this is for the nonprofit. And the reality is that legal aid has already been doing what they're changing the rule to allow. It's already been done. It's not new, it's not innovative. It's being done, but the rule didn't quite catch up with the reality. And so all they're doing is changing the rule to allow it to be what the reality is. So I don't think that unless you break it down into its smallest part and look at it in terms of the big picture, which is how do we protect the public, deliver good deliverables, keep the standard of deliverables to the public where we need it to be, regulate lawyers, provide services again, and at the same time, get innovative. I think that's the whole point of this. Do I agree with all of it? Absolutely not, but that's on a personal level, and my personal feelings don't really matter. The question is, what do you all want us to represent? Because when we go to the meetings, we're going to be speaking for you, and we don't want to do that in a vacuum. So I encourage everybody, please, you know who we are. You've seen us at everything. We're always willing to listen. So call. My number is 954-366-7939. Give me a call, email me. We want to hear from you. You will also have the opportunity to email directly to Supreme Court, Board of Governors. Let everybody know what your sentiment is. But again, I encourage you, as Jay said, not to have a reaction off the bat, but to really break it down into its pieces. And if you disagree, you still disagree, let us know you disagree. That's the whole point of this exercise. So thank you for listening.
Thank you, Hillary. Okay, yes, Paul Regenstorf, you've been waiting, I know patiently to make a quick comment. So, and I know you've done a lot with dealing with a lot of the Florida rules of regs. So,
And Joe after him, I think, has a comment too. I saw that.
I wasn't waiting patiently at all. But thank you.
well, you wrote
know,
you were the first to write in that.
this
So,
This is one of my bugaboos. The question that I asked is, what problem are they trying to address? Delivery of legal services. I think nothing could be more important than finding new ways to deliver legal services. Jay, my good friend, is absolutely correct. Isn't it neat the way we can do Zoom hearings? The reason I was late is I was at a Zoom trial for legal aid, trying to get them 6 figures, maybe 7 figures of attorney's fees so they can better deliver legal services. But when I came back home, my professional lawn care guy was blocking the car of my professional housekeeper who couldn't get out. They're not professionals. I just don't understand why getting non-lawyers into law firms somehow enhances the delivery of legal services. I don't get it. Now, legal aid, somebody said we were already doing this. I don't think so. Legal aid, first of all, is nonprofit. Legal aid is, there's no money motive there. In fact, that's why I'm trying to get money for them, is because they're short of money, but they had a contingent fee. But the point is, legal aid has non-lawyers on their board, but there's no money. They're not driven by the money factor. You put non-lawyers, non-professionals, you know, what makes a professional is not because they put the word professional in front of their name. I had a professional painter out here painting my kitchen after it was redone. He's not a professional. He gets paid for it. That's what makes him a professional. Professional football players. What makes a professional is being governed by guidelines and rules established, self-guidance established by that group of people to govern their own control and practices. It is not that they get paid for it. I don't know. I don't know who said it, Hillary. I have not read all the materials. I have to admit my reaction is knee-jerk to this. And I apologize for that, but I can't deny that it is what it is. I do not see the equation of non-lawyer interest coming into law firms for non-economic control or non-equity control. What does that mean? They can be 49% owner, but the others cannot, and the collective 1,000 lawyers in the firm hold 1% each. Who's going to control that firm, the 49%? I just don't get how that enhances the delivery of legal services, and I don't understand how it enhances our profession. Folks, my professional days are not that many left over. Mr. Kim, I don't know how he's going to vote, but tomorrow he's going to get wisdom because he's turning 40. I'm concerned for our profession, and I don't see this enhancing a damn thing. I certainly don't see it enhancing the provision of legal services. I'm done. Thank you, Jamie. I appreciate your opportunity.
Would any Board of Governor like to respond to that specifically before we go into the next question following through on that?
You know, I don't think, not specifically to that, Jamie. I just want to point out that there were 2 different things there that I think might have gotten meshed together. One is the non-lawyer, non-equity interest in a law firm, one recommendation. Another recommendation, though, is to allow for not-for-profit law firms. And I think that's what Hillary was alluding to. So there are 2 different things. The not-for-profit law firms is generally what are legal aid entities. They are not-for-profit law firms. And what this report is recommending is that we allow law firms, they don't necessarily have to call themselves legal aid or go through that process, but we would allow law firms to actually formulate as not-for-profit entities. And that's my reading of it. And that was what I gleaned from the report. And I think that's what Hillary was alluding to. So there were, you know, there are different recommendations, and those 2 just to separate those. Again, my personal view is I have concerns. I don't necessarily like everything in this report. I do have concerns. But I am here to represent you and your thoughts. And so that's why it's extremely important that we get your thoughts on it, because in the end, you are the ones we represent, and we are going to do that no matter where we may fall on the
Sure.
spectrum.
Thank you, Lorna. And understood. But I want to raise another point, and then I promise, Alexandra, we're going to get to you as well. I feel like I'm on a talk show. But I think it's important what Paul raised and you just clarified from the voluntary bar perspective. This is important. We have an LRS program that is just phenomenal. Our loyal referral service, it's phenomenal. And we serve the community that way tremendously. I mean, Braulio and the team, I mean, it is amazing what a great job they do on that. And the lawyers that benefit in the community, and then the clients that benefit from that. And some of us have been on that lawyer referral service wheel and have done that. So that's very important, Paul. I'm glad you raised that. We don't have to go into more depth, but that is a point I want everybody to look at closely, that Braulio and I have been mulling around, and our board of directors is going to be addressing this at our next Broward County Bar Board of Director meeting, because we feel that that is going to take away a lot from our organization. And that's what we're there to serve as, a not-for-profit. Does anybody have a comment on that before we go then to Alexandra and then Rick Elsley? Oh, okay. All right, Alexandra Ryman, yes, we do want to address that. So what income level is not getting legal services? Sort of goes to that. Why is this proposal to allow a registered paralegal to provide representation and guardianship? So I think your question is specific as to kind of analogizing that, Alexandra?
No, I have two separate issues. I've worked on this issue before when they first proposed this advanced professional paralegal. And I still don't know what the income level is that they believe is not getting served that needs this advanced paralegal. I can tell you my firm is offering a sliding fee scale, and we can't get anyone to take a sliding fee scale. So I can't figure out what this lower income group is that isn't getting services. Number two is we already have a probate rule that says a guardian must be represented by an attorney. So how can we allow these registered paralegals to file things for a guardian when we already have a rule that says you must be represented by an attorney? And lastly, if you're going to allow this registered paralegal to go into court with a quote client, how is what they say the judge did or whatever happened in court not UPL and giving someone a legal opinion about what happened in court?
Does anybody have a?
I think what Alexandra raised are all very good points that need to be pointed out. We don't know if the special committee looked at that. They're going to be presenting their report. But Alexandra, I take your points. For someone who doesn't do probate, I think they're well reasoned, and I would like to be able to present that. So I would say to you, while I know we're trying to take notes while we're here and do that, I would ask that you present that in the Supreme Court input.org, because these are then questions that we can ask the members of the committee, whether they did look at stuff like that, because we all have different practice areas. Now, we do have people on our board that practice probate and trust, and so they may see that also coming at them, and they may be ready to ask those questions also of the committee. So your point is well taken. I am glad you brought it up. And I think it is something that we should have them comment on and address. Absolutely would like to have them answer that question, because I think it's well reasoned and well thought out. So thank you for sharing that with us.
Thank you. Anybody else have a comment on that from the Board of Governors? Okay. The next question was coming from Rick Elsley, and also kind of what you pointed out, Rick, here as a reminder of the regulation then of these non-lawyer entities, right? Rick, did you want to comment further on that and your concerns?
No, I thank you very much. I put it in the chat, but I just wanted to thank the Board of Governors. I mean, each and every one of you. It's it's very important that you are doing what you do, and we all appreciate it. Maybe you don't hear that enough, but really, thank you for taking the time to hear from us and to do the work that you do for as many years as you've all been doing it. So I appreciate that. I just think that one of the things that Paul brought up makes so much sense is we are a profession, and it is very hard to regulate people who are not lawyers. I mean, it's very hard. And when you have investors, which is really what this is, it is kind of like that Ray Abbott thing where all of a sudden, you know, we're going to have reciprocity. You have national interests like LegalZoom and these other investor companies that want to change the whole landscape. And we will change. As Jay brought up, we are doing Zoom. We didn't think about that a few years ago, and that was a necessity. But this kind of change, I believe, changes the character of what lawyers do. And when the profit motive is behind the firms, that is not regulated by the ethical standards that we all grew up in when we were in our 20s in law school and try to live our non-lawyer life by as well, you can't regulate that. And I just think that they're going to be scrambling. I don't know if there would be another division for non-lawyer regulation, ethical. It's just too hard. I see that there's problems with it now with, they say, well, when we have these medical legal service referral services, they still have to abide by anything under the professional rules because the lawyers who take those cases, I think it's a mess. So thank you for listening.
Thank you, Rick. And that kind of parlays into Joe Cashy's point here. Joe, if you'd like to say you had a comment about non-lawyer ownership, was it similar to that, Joe, or something?
Yes, it
further?
is. Of all the things we've discussed today, the non-lawyer ownership of law firms scares me the most. And it's because of what Rick was saying. Lawyers are subject to rules of professional responsibility. Non-lawyers are not. And when you have people controlling the money who only have a profit motive, it's very dangerous. For the first 20 years of my legal career, I was an insurance defense lawyer. I know what it's like having to deal with insurance companies that are trying to interfere with my representation of their insured. I know what it's like to feel as though I was putting my career in jeopardy by standing up for the person I was supposed to represent. I think it's very, very dangerous to have people who are not subject to the code of professional responsibility helping drive the decisions that run law firms. I've also had corporate clients, and I've dealt with corporate legal departments. And I remember one time an employee coming while I was having a member meeting with the corporate legal department, and the employee saying, should we do A or B? A is safe and will protect human life, and B is cheaper. And I saw that lawyer pause for a long time and say, well, let's do the safer one because otherwise we could be subject to punitive damages. I mean, I couldn't believe what I was hearing. I was thrilled that he was doing the right thing, but the fact that the only reason that he was doing the right thing was because of money really scared me. And that's the type of thing that we could be subject to if we have non-lawyers as owners of law firms, and where their primary consideration is profit and not doing what's right as lawyers are supposed to do. I think it's very, very dangerous.
Well taken, Joe. Thank you very much for that comment. All right, we'll have about one more, and I promised you Marseille. Is it Marseille or Marcelo?
And I think Lance also raised his hand. Lance Randall.
Okay, I'm going by the chat. So, okay, Lance, we'll get you next, and we just don't want to go too far over. But go ahead. Let's Marcelo.
Hello, everybody. Okay, I come from a culture which was a little bit different. It's in Brazil. When you have someone who doesn't have the financial ability to hire an attorney, that person fill out the forms to indicate that he doesn't have the ability, and the states subsidize and pay a lawyer for that person to represent them. Okay, it would not happen in Florida. Okay, this is something that they've been trying to do it for many years. That would be the right solution for all this problem. We'll have lawyers representing people, lawyers practicing law, lawyers that went to law school, and they are bound by an ethical duty and rules. Now, I think if they wanted to pass something like this, they have to take in consideration what they're gonna do with everybody else. If you do a Google search today's day, any legal matter, you're gonna come across thousands of non-lawyer things, okay? And that is an opportunity that sometimes becomes harmful for the public. I have seen in my almost 15 years being in the legal field, a lot of people losing the remedy of law because they hire someone who was not capable of handling that situation. It could be an appeal. They didn't know it was a 30-day, or it could be a matter that did require the legal analyst of a professional lawyer. Not only a lawyer, but a professional lawyer, a lawyer that has ability, has been practiced in that area. So I know it pisses everybody off when you see that you went to law school and you spend $200,000 in a law degree, and then you have someone else coming in and just say, okay, that doesn't value anything. Also, for a lot of you, you guys have been dealing with the public for so many years, dealing with a lot of situations. Sometimes you even waive your fees to help your clients sometimes. And I've seen that happens all the time, okay? And sometimes your clients don't even say thank you to you because they believe that your job is easy, which is not true, okay? But we have to be together on this, because there's one part of this situation that I think what they're trying to address, which is the part, if you have a phone call today in your practice and someone doesn't have the ability to pay you, are you going to represent him? And the answer probably is no, not because you don't want to, you want to, but the answer is you have a family that you need to support, you need to earn your living. So if they are putting something together, that if they're going to bring individuals in to work with lawyers, I do that all the time. I work with several lawyers, and they are bounded by rules. They are taking courses. They are respecting that there is a higher authority, and those individuals are professionals that have the duties to be compliant by under a body of laws. Then you're helping the community with those cases that nobody wants, okay? And might be. Now, going to court, and I see someone mention the guardianship, which is true. You for those type of cases, you need a lawyer. That's what the statute says. But going to court, I don't see any on what I read that says that this is allowing non-attorneys to go to court and represent clients. I did not see that in there. If one of you have seen that in there, please send me, because I have not seen that the plan actually is directing non-lawyers to go to court and represent clients. I have not seen that. What I'm seeing is that they were trying to put lawyers to work together with, well, I'm not going to say licensed paralegals or licensed non-attorney, but individuals that are recognized by a body that have rules and laws, and also they have sanctions that can be imposed against them once they violate it under those ethical rules. So we wanted to, if everybody works together, I think it would be opportunities for new lawyers coming in the field. It would be opportunities, but it has to be working together, because I'm telling you, I've seen independent non-lawyers working without lawyers, and they are practicing law, okay? There is no way that you're going to be taking legal questions, legal analysis, legal drafting of paperwork, drafting a motion of this without a lawyer's review, and you're going to just make your own thing because that's what you believe. No, you need someone with a license to review that paperwork. Now, if that person only going to be limited to do that, and that's what the public is hiring for, that's what the public can afford to pay, but they're going to be able to get access to justice, I think is a good thing. So,
Hello.
I'm sorry.
No, thank you. Muito obrigada, Marcelo.
De nada.
And very good points. And by the way, stay tuned for when we do have our next meeting, because our past president, Robin Moselle, put something interesting there. There's a lot of other countries that are doing this. They have the notario system. I know they do where I lived in Colombia. I know they do in Italy. I know they do in Brazil. And so that's a question. Are we going in that direction where that's a cheaper form? Is that what is that? And then it's going to push us out. So these are things, stay tuned. We're going to be addressing these things at our next meeting that Braulio will put together, because apparently we all have some incredible comments, and please put your emails together in the interim to that committee. And if we have to, we'll get John Stewart down here and we'll have him answering these questions.
So we're gonna be having, just so you guys know, on September 8th, the Board of Governors is going to have a Zoom special meeting where we're going to invite the committee, the task force, be asking them many of these questions that you guys have presented. So it's extremely important that you do put a lot of these thoughts in to us in that Supreme Court input at floridabar.org, or directly to us, as my other colleagues have said, by email. So we can ask these questions of them, and if they have looked at it, and how much further into research they've done. They do, to Robin's question, there is an addendum of all the research that they did and where they looked at and all that. So you're certainly welcome to take a look at that. And if you don't find what you're looking for there, Robin, please include that in input to us. And like Jamie says, we would love to do this again. We want your input. We want your feedback. And we want to hear your concerns. So we're going to look to see when we can do this again, but please spread the word that we're having this, and that we want to hear from you, as you guys know, the voluntary bars, I believe, are the heart and soul of the Florida bar. I have said this since day one when I started practicing in 1987, and 34 years later, it's still my belief. And so we are the ones that are on the forefront, and as Jamie says, the innovators, the visionaries, and it's time for us to speak up and share and provide our feedback. And I think Hillary had something she also wanted to say. Jamie, the closing.
I did. I just wanted to point out that we had a lot of questions, but all of the questions were really about the areas that we all kind of concerned about. But what I didn't hear was any questions about fee splitting or educating attorneys about the unbundled legal services. Now, I practice only family law, and I already have multiple cases where I'm doing unbundled services, but I don't know that everybody's aware of how to do that. And then the innovation lab concept. And so there are some ideas already being floated about what kind of things would be done in an innovation lab. And so I just wanted to get if anybody had any comments on that to help me to give questions or reports when the time comes to the committee.
So that would be good to put in that Supreme Court input at floridabar.org as well, or email us as well. And Jamie, I'll let you do the closing.
Absolutely. And if you want to just take your copy and paste what you're sending to them and send them to our BOGs, that might be great too. Then they can chew on that as well and address it at the next meeting. Okay, any Board of Governors want to say anything else before we close up? It's 6:40.
Just
Diana?
thank you for listening.
Okay.
Thank you, everybody, for your participation and your thoughts and comments. Please continue to stay informed on this and voice your opinions through the emails that were distributed earlier.
Thank you. All right, and thank you, and happy birthday, Jay. Go enjoy your.
Thank you very much.
And keep looking young. Thank you, everyone.
Thank you, everybody.
Good night.
Good night.